Diana, can you appeal an acquittal of sexual assault in Canada?
Oh, God forbid. People in the United States cannot believe that in Canada you can be acquitted after going through trial against the state, and they can appeal it. And then if they win the appeal, you have to go back to a retrial again, all over, for the same charges you were acquitted of. People in the States, it's mind-blowing for them. Yet we have a very interesting case. Thankfully, in this case, the person won the Crown's appeal, but the prosecutor, the Crown in Canada, did not agree with an acquittal, and this is the result on a number of very interesting issues. So there were actually...
This was out of Nova Scotia.
Yeah. So there's a Nova Scotia Court of Appeal, and for those who want to look it up, it is on the CanLII database. That's CanLII, CanLII.org. And the case is R.V. Patel, Patel, 2024 NSCA 40.
I think we're going to reference this in our newsletter, our upcoming newsletter.
Yeah, it is. Yeah. And so that's
it's an interesting case.
We have a newsletter that's published by Thomson Reuters now, and it's every 4 months at the moment. But we're going to try and.
It's going to be every 3 months now. Yeah. Unfortunately, not on our website anymore because Thomson Reuters picked it up. So
Crown appeals. Crown appeals are really limited, so you can appeal a conviction on a number of different bases on a little bit lesser standard of whether it has to be an error of law alone, right? And but there were 4 different grounds, actually 5.
Yeah,
one of them is my favorite. So
it's supposed to be an appeal on a narrow area of law, but I mean on an area of law. But it's supposed to be, the Crown's right of appeal is supposed to be narrowed. It doesn't seem that way to me in practice, but anyways.
And one of the reasons when I say it's my favorite, it's actually my least favorite because this is too common. But they allege stereotypical reasoning on the part of the judge. And what I've found before is that in cases, if there's a possibility of a stereotype, then the appeal gets granted and they have to go back to retrial just That's because... Right. You can interpret the way the judge said something to think that they employed a stereotype. And, oh my goodness, what if that was what they were thinking? Whereas if you're appealing a conviction and you allege stereotypes in some way, they kind of go, oh, well, we have to go and we can't parse out everything.
Well, and Kruk changed what is a reversible error versus what has to be a palpable and overriding error. If you want to
know what Kruk is, go watch all of our episodes because we talked about it in detail.
Yeah, but they changed, Kruk, the Supreme Court of Canada decision, changed what might be, as they called it, an unsupported assumption, what we called stereotypical reasoning, is no longer, a reversible error. It has to be a palpable and overriding error. So that's appellate speak for the fact that it's a little higher threshold to try and overcome that error and get a new trial ordered. But we discussed that a while ago, and that has a lot to do with appeals. But this is a very interesting example of a Crown appeal of an acquittal, and they lay out a number of constellation of errors. It's just, can I just raise them for a second and you give the factual matrix?
Yeah.
So the Crown alleges, the trial judge is alleged to have committed a constellation of errors. Piecemealing of the evidence.
I was just going to get into
It's just very funny. Failing to consider the whole of the evidence related to the live issues at trial. Misapprehension of the evidence. It sounds like a defense appeal. Explicit refusal to apply common sense and human experience to his assessment of credibility.
Common sense used to be the thing the Crown used to be like, oh my God, they used common sense.
I know. Stereotypical reasoning. So those were the grounds of appeal. Go ahead, Diana.
Then they give a background, and just so people have an understanding, this is a situation in which somebody who's kind of a homebody or whatever wasn't leaving the house very often, did a lot of takeouts, had a regular delivery person who came over, and on one particular occasion, they ended up having sex when the delivery occurred. And there was a dispute.
Was it a pizza delivery guy?
It was a pizza delivery guy.
It's like a movie. Okay, we love this just because it's like a movie. Okay, the pizza delivery guy and the customer.
He ordered that hot, extra spicy, right?
Hot extra spicy with sausage.
So for one reason or another that is under dispute between the complainant and the accused, they ended up having some sort of sexual interaction, which was not refuted. The accused agreed that there was some sexual interaction, but it was very disputed as to why this took place and how it took place. And so then the judge heard the evidence and had a number of issues with the complainant's evidence. I'm on page 4.
No, I know. I love the facts of this case.
I know.
It's just like so movie-like.
So the trial judge ultimately did not find the complainant credible in relation to the critical issue that he had to decide whether or not the Crown had proven beyond a reasonable doubt that she had not consented. He found aspects of her testimony taken with his, the accused denial raised a reasonable doubt, and made it clear that in assessing the credibility, that the trial judge was not choosing which version to be more believable. That's so important.
Right.
That he recognized he could not decide that the complainant must be telling the truth on the basis of querying, why would she lie about something like this? Also important.
Right.
Right? So then they kind of review the way, and this is interesting, and I want to make this point. When people read these decisions, they get a little bit confused sometimes because the decisions start out by summarizing what the issues are. Then they give the background of the case, and they summarize what the complainant said, what the accused said, and then they look at the legal issues and then they describe how they come to their conclusions. So a lot of people, when they read these as they're going through stuff, and then also they'll summarize what the Crown's submissions were, what the prosecutor in the States, and what the defense submissions were. Those are not the trial judge's findings. The findings come at the very end of the decision.
Yes.
And so a lot of people, what I found, lay people who are trying to read these cases, they get really confused because the judge will be summarizing what the submissions were, and they'd be like, oh, they found this and that. And it was like, no, they didn't. They're summarizing what was presented to them.
It's an analysis. Yeah. So, but let's talk just a little bit, because it's just an interesting case. So, yeah, pizza delivery guy, customer, allegedly
Spicy.
not spicy sausage, non-consensual sexual intercourse. Okay. The trial judge, according to the appeal court, undertook a review of the legal principles governing the reasonable doubt standard. The judge recognized he was not able to apply the standard to individual pieces of evidence. He quoted at length from one of my favorite cases, Nisnik. Justice Malloy, a decision of the Ontario Superior Court of Justice relied on by the respondent, which held that the focus of a criminal trial must always be on whether or not the alleged offense has been proven beyond a reasonable doubt. In the analysis, the trial judge made the following findings in assessing the credibility and reliability of the complainant and the respondent. The respondent had deliberately avoided telling the police the truth about the sexual encounter with GM.
So the respondent is the accused.
Yeah. In his testimony, he refused to admit that he had misled the police. People lie about having sex.
This is my favorite part.
Yeah, go ahead.
So far.
Yeah.
People lie about having sex. The respondent's lies to police did not mean the sexual activity with the complainant was not consensual.
Say that again.
Slow it down.
No, this is really important. This was a really good case.
And this is important too, because when an accused person is talking to the police, who they generally are saying, I don't want to give comment, and they might say, oh, it didn't happen or something like that. People lie about having sex, and the respondent, the accused person's lies to the police, which came out at trial, did not mean that the sexual activity with the complainant was not consensual. So just the fact that they lied about it and denied having sex at the beginning cannot be used to convict them, because people may not want to admit to having sex when they're speaking to not just strangers, but to the police.
Right. And in fact, it was found here that the accused lies to police and his failure to acknowledge them undermined his credibility, but were not determinative of guilt. The GM's description, that's the complainant, and detailed testimony about her interactions with the respondent at the front door of the apartment and in the bedroom contrasted with her lack of description about how she went down the hall to the bedroom with the respondent was a factor for the judge to consider. The respondent and GM's descriptions of their interactions did not differ greatly in the amount of time involved. The short duration of their time together goes through a whole host of facts. I'm just trying to go through it. the complainant subjecting herself to the sane examination,
That's interesting.
which is the sexual assault examination,
yeah.
may
some
indicate
people-
she was telling the truth about what happened, but was not determinative. The complainant's confusion over the sex, when the sex occurred, when she went to the hospital for the examination, did not support her credibility. The complainant's lack of detail concerning how her pajamas were removed, etc., was not compelling and convincing. Like, this judge goes through a whole analysis with deficits on both sides. That's just why I'm going through this.
And I feel for judges because, I mean, this seems like a very thorough explanation of how the evidence was assessed, what was given weight, what wasn't given weight, and yet it still gets appealed. And there's like, I really feel for judges and like the pressure on them to give sufficient reasons. I mean, how much more thorough can you be than this?
No, this is a perfect example of a judge giving a very thorough analysis based upon all the evidence, doing a very thorough WD analysis, assessing and really fairly assessing.
WD analysis is the reasonable doubt.
Well, how to assess the evidence of an accused and a complainant, as set down by the Supreme Court of Canada, which was
If you believe the
Regina versus
accused, you
WD.
must acquit. If you don't believe them, but it raises reasonable doubt, you must acquit. If you look at the whole of the evidence and it's and you still have a reasonable doubt based on the whole of the evidence you do believe, then you must acquit. So that's the summary of WD. And this, as you said, was very thorough in terms of going through all those steps.
And the trial judge found that the accused testimony that there was consensual sex, combined with the problems that the judge identified with the complainant's evidence, raised a reasonable doubt about the complainant's claim that sexual activity was without her consent. This was a very good analysis of all of the evidence with problems on both sides, and in the end, he was left with reasonable doubt.
Yeah, and that's
But it's not. This is not something just to be go, okay, good. This was a really good analysis of a difficult case, where it could have been easy for a judge to convict.
And the fact that the judge recognized, or decided, maybe just decided there were problems with the accused evidence does not mean that you automatically then believe the complainant. Even though there may be some things that an accused person says, you kind of go, yeah, I think they're full of shit on that one, right? But it can still raise a reasonable doubt. And this is a case that really highlights that, I think.
Yeah, and talk, you know how scared I am of when doesn't hang together well, right? Because I firmly believe in the presumption of guilt, and that you got to be really careful about...
The best way to get an acquittal is to make sure that you go in assuming that your guy's going to be presumed guilty. That's the best way to approach it.
Yeah, so I think it's extremely important to be careful about the defense narrative. But this is a great case of a very fair judge who did a very fair analysis on it. And then, and in particular, there was this desire on the appeal to try and say that the judge engaged in stereotypical reasoning and a refusal to use common sense. Yeah. This was something really pushed by the Crown in this case, which is kind of funny, as you said, because before, common sense was really a dirty term.
Oh, yeah. It was just like cringe moment for a judge. As soon as you brought it, I'm going to go stay on page 8 because I can see you're on 16.
Sorry, I moved ahead.
So the appellant, which is the Crown says that the prosecution case was never properly assessed with its full cumulative force. Conversely, that the accused evidence was given undue credence by virtue of a legal analysis that does not properly reflect the law of reasonable doubt. And they criticized the judge for what they claim was a failure to assess the accused evidence against the evidence as a whole. So
seems like a pretty broad attempt to overturn an acquittal by the Crown, does it not?
Yeah, it's really asking the Court of Appeal to retry the case.
And it was an unreasonable verdict.
That's what they're saying.
It's not within the lane that the Crown should be appealing.
So what does it mean to piecemeal the evidence?
Good question.
At paragraph 41, the appellant says, the Crown says, the judge subjected individual pieces of evidence to a reasonable doubt standard or considered evidence in isolation, siloed from the remainder of the evidence. Again, this is, what do we get when we see conviction appeals? You can't parse out the evidence. You can't parse out the judgment, You can't parse out the judgment to assume that the judge did not consider the evidence as a whole. And yet now they're saying, oh, well, we're saying that the judge acquitted because they looked at the evidence as a whole, and sorry, they didn't
look
consider
at
it as a whole.
They
and
did in a
instead,
piecemeal
they
fashion.
paid too much attention to detail, is what they're saying. They paid too much attention to detail.
Let's just break this down for a second. So let's just understand what the standard of review is when you're doing an appeal as the Crown against acquittal. Pursuant to Section 676, Sub 1 of the Criminal Code, the Crown's right to appeal an acquittal is limited to questions of law alone. This means that the Crown appeals against acquittals in proceedings by indictment cannot be reversed unless an error of law has been established. The Crown has no right to argue on acquittal should be overturned because it's unreasonable or otherwise unsupported by the evidence. This is because the underlying reason for a judge's acquittal of an accused is a finding of reasonable doubt, a determination that is a finding of fact or mixed fact and law. The acquittal based on a conclusion of reasonable doubt unsullied by material legal error is not amenable to appeal. So just think about that standard of review. That's this narrow standard of review for an appeal by the Crown against acquittal. And the arguments in this case is about an unreasonable verdict. That's really what it is. And it's disgusting in my opinion. But it's a great analysis here.
Yeah. And we've seen that before, is there's no such thing as an unreasonable acquittal. There's an unreasonable conviction.
Yeah.
Unreasonable finding of guilt, but there's
100%.
no such thing in law as an unreasonable acquittal. So now I think you went to page...
Yeah, I just wanted to go because the Crown is arguing about stereotypical reasoning and refusal to use common sense, which is so funny to me because for so long they were arguing about how judges cannot use common sense because it leads to stereotypical reasoning. In this appellate decision, I'm not persuaded the trial judge refused to apply common sense and human experience in assessing credibility. He reached certain conclusions based on the evidence and made unfavorable credibility findings in relation to both the complainant and the accused. Appellate review must treat those credibility findings differentially. So they must defer to the decisions or assessment of the trial judge. The appellant has not shown what common sense and human experience, the Crown experience, human experience, the trial judge should have applied and how it would have led to a different result. In my view, this is another submission that effectively invites us to reweigh the trial evidence and reach a different conclusion than the trial judge. That's very dangerous. So good for this Court of Appeal. But that's dangerous. This is really asking an appellate court to retry a case, which is not the standard of review.
And if it was in the reverse, where it was conviction, they would argue the complete opposite thing. This is the thing that drives me mad, right? But what we're getting to my favorite part, the argument about stereotypes.
Yeah, go to it because this is good.
So, because in my mind, when I read this, I thought that the Crown prosecutor was trying to come up with a new stereotype that doesn't exist before. But
do this slowly because this is a good one.
Right. So stereotypical reasoning, refusal to use common sense, again, and they said the grounds of appeal kind of combine into two different things.
Yeah.
So they say, I'm not persuaded the trial judge refused to apply common sense and human experience in assessing credibility. He reached certain conclusions based on the evidence and made unfavorable credibility findings related to the complainant and also to the accused. That they have to treat those credibility findings differentially. I'm going to skip to the next paragraph. In conducting his assessment of the complainant's credibility, the trial judge did not commit legal error by relying on stereotypical reasoning that a sexual assault complainant's lack of detail in relation to aspects of her interactions with an accused was evidence that she could not be believed. Right? So we're dealing with this thing. It's like, complainants are not expected to give details.
It's dangerous. So he did not make a finding that a sexual assault complainant who does not provide a detailed narrative is unworthy of belief. But maybe it is a ground to find somebody not reliable. But leaving that aside, he did not invest the complainant's lack of detail with a stereotypical meaning, one rooted in discrimination and inequality of treatment. The trial judge viewed the missing detail as a contrast to the details of the accused provided about the interactions with her in the kitchen and in the bedroom. It's not impermissible to take memory gaps or the absence of detail into account in a credibility assessment. Very important.
So,
Should we repeat this? Yes, we should.
it's so important.
Just for a second,
It's
okay?
so important.
Because it took us a while. This may be a bit torturous, okay? But it's a Crown appeal against an
Torturous to
acquittal.
other people is so funny because we love our job, right? To us,
we
this
do,
is
but
exciting.
It is,
exciting.
but you got to get through all this. This was an interesting appeal where essentially I think the Crown was arguing an unreasonable decision, okay? And they were trying to argue all sorts of shit, which was not in the purview of what is the scope of review on an appeal. That's what really I thought was going on
And this
here.
is the last. This is the last grasp at an attempt was to add a stereotype allegation.
So a complainant cannot be discounted simply because they can't give certain details about what happened. Okay, I get that. Because there may be difficulties with it. But it does go to credibility. And God bless this decision. The trial judge viewed the missing detail as a contrast to details the complainant provided about her interactions with the accused in the kitchen and in the bedroom. It is not impermissible to take memory gaps or the absence of detail into account in a credibility assessment. That is the f***ing law.
What do we see though when our guy or our client,
Explain
be
it.
it male
You're
or
right.
female, when our client can give detail, the Crown quite often goes, "Well, why do you remember everything?" And they try to hold it against them that they actually have memory.
Have memory.
It's unbelievable.
And then on the flip side, oh, well, you don't remember this, you don't remember that, you don't remember this, therefore you're not reliable or credible. You cannot win as an accused, right? If you remember details, there's no reason you should remember it unless you suffered a trauma. And if you lack detail, you should not be believed. That's really the catch-22 that an accused is in. But why we got to this was the argument was so interesting here that this was basically an unreasonable acquittal. That was the argument by the Crown, which is beyond the scope of review, in my humble opinion. Others may disagree who are appellate lawyers,
Well,
but
they'll
I
have to
think
disagree with the Court of Appeal.
I agree with the Court of Appeal on this one. I think our analysis is in line with the Court of Appeal. And the money line here is, and this must be remembered, because this is very important for all future trials. And I wish this would have gone to the Supreme Court of Canada and be supported by it, because we need to hear this again and
I'm afraid
again
of the
and
Supreme
again
Court.
from Supreme Court of Canada. A trial judge can take into account lack of detail and lack of memory in assessing credibility. Period. Full stop.
Good decision.
Yeah, really important. Please send us your questions, your emails, your comments, because we feed off of it. It's very helpful. We really enjoy it. And, we come across these cases as we're writing for our newsletter, and just sometimes it has nuggets, like just these really great nuggets, not chicken nuggets, but really good, healthy nuggets for our analysis. And this was like just an interesting one, and I hope we're going to use this in our
Oh,
in our
absolutely.
arguments.
It'll be in the newsletter.
This is going to be,
It's going to be
but
in
this
our
is going to be in
arguments.
all of
Yeah.
our written submissions.
Yeah.
This line cannot be ignored, because so many times they try and say the lack of detail doesn't matter. It doesn't matter. The core of
does.
the evidence is there. I was sexually assaulted. The core of the evidence, I was sexually assaulted. That's it. But all the other memory gaps, like I don't remember 2 hours before being sexually assaulted.
Yeah.
I don't remember getting into bed. I don't remember why my clothes came off. I don't remember why I was giving a blowjob, but I was sexually assaulted.
We
There-
weren't even intoxicated at the time.
yeah, like all that. So this is extremely important. Good decision, Nova Scotia Court of Appeal.
Yeah, absolutely. So subscribe.
Not just do they have a great view of the ocean, it's a really great decision.
To keep this channel going and spread the word, subscribe, hit notifications, like, and
Share
leave
and
comments.
subscribe or whatever.
Yeah,
Thank you. But send us those questions. Keep going. Thank you very much, SpongeBob. Why am I saying SpongeBob? Because Max, our producer, is wearing a great SpongeBob shirt. Good night.